Welcome back to our 30-day SHRM-CP exam prep course. This is week 2, day 9. Today we're diving into a core HR responsibility with our guide, Babu, managing FMLA requests. Picture this. An employee hands you a doctor's note. It says they need 12 weeks off for a serious medical condition. What do? Can the company just say no? This is where mastering the Family and Medical Leave Act, or FMLA, is non-negotiable. So what's the first rule? FMLA is a federal law providing eligible employees with up to 12 weeks of unpaid, job-protected leave per year. But who is eligible? It's simpler than you think. The employee must meet 3 key criteria. First, they've worked for your company for at least 12 months. Second, they've worked a minimum of 1,250 hours over the past 12 months. And third, they work at a location where the company employs 50 or more people within a 75-mile radius. If they check all 3 boxes, they're eligible. Now let's talk about that crucial phrase, job protected. This is step 1 for Babu. It means that when the employee returns from their leave, you must restore them to their original job or an equivalent one. An equivalent job means the same pay, benefits, and other terms and conditions of employment. You can't simply fill their position and then offer them a lower-level role when they come back. That's a direct violation of FMLA. Here's a classic SHRM exam scenario that trips up a lot of people. An employee with a history of poor performance suddenly requests FMLA leave. Their manager, frustrated, wants to terminate them before the leave even begins. What's the right move? As Babu would advise, you cannot fire an employee because they requested FMLA leave. That's retaliation, and it's illegal. However, the key here is timing. If the decision to terminate was already in motion, documented, and approved before the employee requested leave, you may be able to proceed. The FMLA request doesn't shield them from a legitimate, pre-existing performance-based termination. Documentation and timing are everything. This brings us to step 2, certification and documentation. When an employee requests leave, Babu's next action is to provide them with the official FMLA certification form. This form must be completed by their healthcare provider to verify the serious medical condition. HR has the right to require this proof to validate the leave. And throughout this entire process, from the initial notice to the final return to work, meticulous documentation is your best friend. It protects both the employee and the company. So, let's recap today's critical lesson. FMLA grants 12 weeks of unpaid, job-protected leave to eligible employees. As HR professionals, our job is to verify eligibility, ensure the employee's job is protected upon their return, and make certain that no disciplinary action is taken as retaliation for requesting leave. Babu successfully navigated this compliance challenge, protecting the company from serious legal risk. Great work! Tomorrow, we'll continue with benefits in week 2, sequence 10, as we tackle another essential law, COBRA. You won't want to miss it. Thanks for joining today's session. If you found this helpful, make sure to hit that like button and subscribe so you don't miss a single day of our 30-day prep course. See you tomorrow.